Great. Well, we'll get going. Again, just want to welcome everyone for joining and listening to the presentation on Trump tariffs, where we are today, and what importers can do to minimize these duties. I'm excited about our two presenters today. Known and worked with Robert Silverman for a long time. He is a founding member of GDLSK. He has been a counsel in over 125 decisions issued by the U.S. Court of International Trade, U.S. Court of Appeals for the Federal Circuit, and a number of U.S. district courts. These courts' actions have involved a wide array of customs issues, including tariff classification, customs valuation, country of origin determinations, exclusions based on claims of forced labor, record-keeping penalty cases, and Section 1592 civil cases. So excited about that. And joining as well is one of Robert's partners, David Murphy. He has more than 30 years experience in handling complex cross-border issues with respect to customs and trade, including U.S. import and export control, classification, valuation, marking, origin, licensing, and other governmental agency requirements, including audits, investigations. Again, excited, appreciate this. I know this subject is touching a lot of our clients, as well as other individuals that we know. So I'm going to turn it over to Robert and David now, and look forward to hearing what insight you have to share with us.
All right. Thank you very much, Cory. It's hard to believe this president has only been in power since January 20th this year, because so much has changed. And not only that, but it changes every day. We can't do one of these programs without checking today's news articles, news feeds, or whatever. And in fact, there was something just yesterday that made a change. David and I'll go through the slides. David's going to talk about the changes that we've seen in the law. I mean, it may be a little more technical than you folks want. You're not customs brokers, but you have clients who are in the import business. I'm sure you're getting a million questions. So David's going to go through the changes that we've seen, and then I'm going to talk about what we're doing with our clients to minimize the customs duties. The other thing is, as he goes through these slides, you'll see some of these items are highlighted. Those are proposals. Those are things that are yet to come. We don't know if they'll materialize or not. Plus, there's always something every day with this particular administration. So with that, David, why don't you start taking these folks through?
Okay, so where we've been. Under the first Trump administration, we saw the China 301 action that imposed between 7.5% and 25% on a scope of goods, pretty much everything exported from China, for that were subject to these 301 duties. These had a number of exclusions. Those exclusions have either have expired or are expiring shortly, and all these goods are subject to those additional duties and continue to be so. Also, under the first Trump administration, we saw an investigation involving the European Union and large civil aircraft. While there was duties imposed for a short time there, those have since been suspended for a period of 5 years through 2026. Whether those are coming back, we'll see. We'll talk about the other duties on goods out of Europe as well. Also, the other investigation on digital services tax. Digital services tax imposes local taxes like a VAT on digital services in various countries. This was initiated over 11 different countries. There were tariffs announced. However, there was an agreement reached and action was suspended. So that is currently back in the background as well. And then our 232 tariffs. Now, Section 232 is the provision that provides that the president and the administration can impose tariffs based upon a national emergency. National security. And based upon that, in order to support the steel and aluminum industry in the United States, under the first Trump administration, we saw imposition of duties on steel and aluminum up to 25%. Aluminum rates went up to 25%, and there were certain exclusions under this process and an exclusion process. But we'll see the changes under Trump 2.0, the second Trump administration, that those have been restricted quite a bit as well.
Yeah, so under the first round, it was 10% on aluminum, 25% on steel, and then the administration was making deals. Some people got quotas, some people got exclusions, some people got exemptions. It was all different kinds of things, and all that's gone. It's 25% across the board on these things. And David will you'll see this section 232 on steel and aluminum, iron, should be iron, steel, and aluminum, come up again a little bit later in the program.
And derivative products, which is the big
Yeah.
issue today. Automobiles, including cars, light trucks, and vans, SUVs, and auto parts. This is an investigation that again goes back to Trump, the first Trump administration. There was a determination that for national security purposes, they were going to take action, but no action was taken during the first administration. We'll talk about the more recent action on this a little bit later. Okay. Canada and Mexico, beginning, as of the inauguration of President Trump, he went to action on his tariff plan, and one of the first areas he hit was Canada and Mexico with tariffs of 25% that went into effect on March 4th, 10% for energy imports from Canada. And he did this under a new provision, the International Economic Emergencies Act, which allows for the declaration of a national emergency and taking action. This was the first we've seen any action under this statute for this type of purpose. We've seen it for export control and things like that. And effective March 7th, there were goods that were exempted from that 25% across the board if they qualify for USMCA treatment. In other words, the goods qualify as originating under the US-Mexico-Canada Agreement, General Note 11 to the tariff. So you could still have a product of Mexico that is still subject to the 25 because it's not claiming USMCA treatment.
Yeah, so USMCA is basically the new NAFTA, right? So if you qualify for NAFTA, you're not getting hit with this 25%.
Right. And that's at this point still in place and appears to be continuing in place for the time being. But be careful if you do not qualify for USMCA. In other words, claim it at the time of entry. You are going to be subject to the 25%. We've seen a rise in claims under USMCA, and we'll talk about the problems with that. Want to be careful with those. Especially with unconditionally duty-free goods. These would come in subject to merchandise processing fee if USMCA wasn't claimed. If you claim USMCA, it was exempt. And in order to avoid the 25%, as I mentioned a little bit earlier, you have to make a USMCA claim at the time of entry. In order to do that, you have to, one, assure that your product meets the originating status under the agreement. It's covered under a certification, and having the underlying documentation to support that it does meet originating status. And this originating status can be problematic in the sense that there are different rules for different products. Some are subject to a strict tariff shift rule, which means the materials that went into it as a result of production or manufacture change the tariff classification of those goods to the final classification of an imported good. In addition, some require a regional value content. This regional value content, either 60% or 50%, depending on which method you use, also requires certain local content, being Mexico, Canada, and the US. As a result of the increase in claims, or probably also on the overall enhanced enforcement, we're seeing a number of CBP verifications of these USMCA claims, and we can expect that to continue as well.
Yes. So let me give you an example here. I had somebody reach out to me. These people imported tequila from Mexico. They had to pay IRS taxes, but it was duty free otherwise, right? There's no ad valorem duty on it. And it's not listed in the tariff schedules as eligible for this USMCA program. But because it's categorically duty free, it is eligible for it. These people didn't realize they had to make a claim at the time of entry, and most important, they needed a certificate of origin to make that claim. And as David said, Customs is sending out inquiries to confirm that people meet these tests. If not, 25% is a big number.
Yeah, we're going to come back to the time of entry issue as well, because that becomes key in a lot of these issues. China. So again, there was an international emergency involving fentanyl, which was the basis for the Canada-Mexico and immigration for Canada-Mexico. But for China, it was based upon trying to stop the flow of illicit drugs. So there was first an additional 10% that went up to 20% on March 4th, based upon this emergency. And there was a restriction on the use of de minimis. And if you're not familiar with that, that allows for low value shipments under $800 to clear without entry and duty. This is basically your internet packages type idea. That has been eliminated for China as of May 2nd. It was first restricted, then brought back, all sorts of things, but we'll talk about that more in detail a little bit later.
So this is e-commerce, and I think they say about 70% of import shipments for these little shipments come from China. So it's a major problem for Chinese exports.
Yep, and there was initiation of an investigation back in April involving maritime industry involving China, trying to reinvigorate the U.S. maritime industry and elsewhere, I'm sure. The investigation concluded that there was an issue of national security. 301, unfair competition by China. It's tough to keep all these straight. That due to their shipbuilding activities, and there has been a proposed fee. There has been now a final determination, right, Bob? And I don't think there's an effective date yet, but there will be some sort of fees if it isn't dialed back.
I think the biggest problem is maybe a bigger problem for certain parts of the country. I think ordinarily a vessel would come in, let's say, and dock and unload things at 3 or 4 ports in the United States. And under this program, they're looking at charging them at every port that they unload merchandise, which means they may just unload in one port and not go to, for example, they'll go to New York, but not Philadelphia and Baltimore. I mean, which is going to be a major problem for importers. Plus, it's going to be expensive.
Yes, yes. Then on April 9th, Trump rolled out his reciprocal tariffs against all our trading partners because of the unfair assessment of U.S. exports in those countries, again, under this national emergency. Here, the national emergency was the trade deficit with all these countries. As rolled out, there was a flat 10% that would then go up to a reciprocal tariff rate that varies by country. And we'll come back to that in a minute. But goods exported before April 9 and entered before May 27th were exempt from these reciprocal tariffs. On April 9th, he reduced the reciprocal tariffs, except for China, to 10% for 90 days. China went to 125, with, in addition to the IEEPA tariffs, is 145% on Chinese products across the board.
Yeah, so he did that for China because they had the nerve to say they were going to charge tariffs against products going from the United States to China. So there's about a half a dozen lawsuits pending in the Court of International Trade challenging the president's authority to impose tariffs under this statute. They say he doesn't have the authority, one, and two, this statute doesn't permit the president to impose tariffs. And then let me see, there was another, oh yes, that oh, I forget the other point. Oh yes, that there's no emergency. I mean, these
Right.
tariffs have been in place for 50 years. So there's certainly no emergency. Anyway, we'll see. They're trying to get an injunction, preliminary injunction to stop the president. I think we'll get an answer on that within the next 30 days. We'll see how that goes.
Okay.
Okay.
And with these reciprocal tariffs, there was also a number of exclusions from them. Goods already subject to 232, such as our steel and aluminum, and now autos and auto parts. Those, if they're subject to those 232 duties, they're not subject to the reciprocal tariff duties of 10% or 145. Also, there was a blanket across the board exclusion, which we've seen in other presidential proclamations as well, for, well, informational materials, which has its own definition, but under IEEPA that can't be imposed. But also goods entered under Chapter 98, except for the provisions that provide for foreign processing, the 9802 provisions. There, the duty, the reciprocal tariff rate applies to the foreign materials and processing done abroad. But otherwise, the U.S. content or U.S. originating, whether exported or originating in the United States content, is exempt from it. There are a number of Chapter 98 provisions, and we're seeing a lot of activity in that area for people to see if they can qualify. Then on April 11th, President Trump dialed back the duties on certain electronic products, smartphones, computers, etc., retroactive back to April 5, if they were classified in certain provisions. You know, they left open the door whether or not this could be revoked or limited. And so we'll have to see where how that stands in the future. But also around about the same time, there was again a national security investigation on semiconductor products that has been initiated. We're waiting for the report on that to see what additional duties they want to impose under those. Okay, so getting back to our 232. So beginning on March 12th, for aluminum, it was originally 10%, as Bob mentioned. That went up to 25. Our steel tariffs were already at 25. All current country and product exclusions for steel and aluminum were either terminated or allowed to expire. Some are based upon quantity, some are based upon date. So there might be one or two still hanging out there. And then it expanded the 232 duties on what are called derivative products. These are products that contain iron, steel, or aluminum in them. These are now subject to these 25% 232 duties. And they also have a set of exclusions. Steel that's melted and poured in the United States, aluminum smelt and cast in the United States. And, you know, there's some questions on this about not only what, you know, what level of U.S. melt and pour or smelt and cast, what if only part is smelt and cast? Does the entire article get exempted? There's whole issues on values on this, because you have to report the steel and aluminum value, which can be difficult. And the effective date. So for chapters 73 and 76, that's, you know, articles of iron and steel or articles of aluminum. the duty of 25% applies to the entire product, regardless of the nature of other components or materials in it. For anything outside that, those two chapters, for example, Chapter 85 or 94 for furniture and things like that, the duties went into effect also on March 12th, but the duties are limited to the value of the steel or aluminum content. And as I mentioned, there is a big issue of how do we value the steel or aluminum. Customs directives on this have been very unhelpful as far as nailing that down, just some general guidance. But that will become an issue as customs begins to look at those values.
Yeah. So let's give an example. Let's say you're importing a lawn chair, one of those plastic web things that's got an aluminum frame, and you're classified under some Chapter 94 provision for furniture. You're going to have to figure out, and assuming that particular provision is on this list of derivatives that are hit by this program, your client's going to have to figure out what's the value of the aluminum in there, and then you're going to have to pay 25% duty on that. Sometimes, believe it or not, that 25% duty is better than paying the 125% duty that comes for items that are not hit with these 232 duties. So it's a hunt and peck kind of business.
Correct. You got to analyze each product to see what is most beneficial for you. Then on March 26th, he rolled out his tariffs on imported automobiles and automobile parts, again under this national emergency idea. We saw the prior investigation under 301, with unfair trade practices, basically because foreign countries were imposing duties on our cars and auto parts higher than we're imposing on theirs. And so for full automobiles, those went into effect on April 3rd of 25%. Automobile parts is still slated for May 3rd, but we're seeing some movement on that. I'll talk about that in a second. These duties are in addition to other duties and fees applicable to the imported automobiles and automobile parts. And there's an exclusion for the U.S. content, meaning if you can show that a certain portion of it is a U.S. component or possibly material, then it would be excluded from these tariffs, and also our USMCA exclusion. In this proclamation, he provided that there is no drawback applicable toward these duties, drawback being the refund of duties upon the export of a product from the United States. So if we were importing parts and assembling an automobile and exporting it, these parts would not be subject to drawback. These are exempted from the reciprocal duties as of now. There was a pause announced for the auto parts that we heard about. And then just yesterday, there was a mention of, also a proclamation that would exclude certain, give a credit for certain components and parts that are subject to other duties like 232, based upon the manufacturer selling retail price of certain things. We're still investigating that to see how that's going to work, but there's some loopholes there as well.
That one's really different than everything else we've seen, because it looks like you're getting a credit when you sell these cars based on the tariffs that you paid. You're going to have great inventory controls to be able to trace everything.
Right. As you can see, the scope of this is extremely broad. All sorts of materials that go into an automobile would be on the parts provision. The vehicle provisions are pretty straightforward, but the parts provisions are pretty wide that we can see. Okay. So with each of the various bases for these provisions, there's a a statute underlying it, and each one provides a process for the implementation of these. Under 301, like we saw under the first administration, there was an investigation on China that took several months. There was notice and comment. People went back and forth prior to the implementation, publication of lists that were subject to it, and there were goods subject to specific exclusions, again, based upon presidential authority there. That process now is gone. 232, the same thing, while it provides for a 270-day investigation, and in the past those would utilize that time. We're seeing a much shorter time frame today for those reviews. Now, while 232 doesn't specifically provide for notice and comment, so far we've seen that they have allowed notice and comment on these newer investigations. And I'm sure in that notice and comment, people are trying to lobby for certain exclusions. Whether or not those will go forward in the new investigations or elsewhere, we will see. Oh, backing up on 232, there is also the possibility of expansion of the list of derivative products for steel and aluminum in the new round of those. And the IEPA, it's a little bit more fuzzy. There is no underlying investigation. There's simply a declaration of an emergency by the president, which allows him to take action. They've interpreted the statute of allowing them to impose tariffs immediately, and I believe the statute does provide that as an alternative, but the question is whether they're properly doing it is one of the issues. Okay. So, while like I said, there is a process, we're seeing changes in the process. One, by the agencies expediting their reviews, but also in the implementation by the administration to expedite the imposition of these duties. So, reliance on that it's going to happen down the road is a little bit less certain these days. Okay. As we mentioned earlier, the issue of date of entry has become a significant issue. The majority of these proclamations state that these duties are effective on the date of entry for consumption or withdrawal from warehouse for consumption. That is a term that's used extensively in the customs area and has a certain meaning under the regulations. Basically, when you make an entry, if you don't do anything, the date of entry is defaulting to the release date. But in no case, even though we pre-file entries and we may get an electronic release of those goods, that release date gets updated based upon the arrival. So in no case can your date of entry be prior to arrival. There are a couple of ways to lock in your date of entry. One is to file what is called a live entry. Now, with warehouse withdrawals, essentially all your warehouse withdrawals are live, because that requires the filing not only of the release information, the entry information, but also the entry summary, all the detail information in proper form, and arranging for the payment of the duties. Generally, that will lock in your date of entry based upon the date of our presentation or filing of the entry in most cases. There is also a process whereby there can be an elected entry date, so long as it's after the date of arrival, that even though our goods may not get released, it would be effective as of the date elected for that.
Yeah, these are all issues that your clients need to take up with their customs brokers who are filing these entries to get them in before these tariffs hit, if possible.
Yeah. There is a process called a special permit for immediate delivery. It's extremely limited, basically Canada, Mexico goods, certain perishable goods, things like that, where the goods come in, they get released immediately. But under they're really released under bond, and your release date and your date of entry will not be until the entry summary is filed. This is used in a lot of agricultural quota issues and things like that, where in cross-border movements. But there, if you delay the filing of the entry summary, that's going to delay your date of entry, which could affect what duties are applied. There is a provision in the regulations which allow, when goods arrive, let's say on the West Coast, and you move them in bond, let's say to an inland port, that our duty rates are effective as of the date of what we call an IT. That's a transportation in bond entry. And there's a question whether or not it applies. I've had some disagreement on that, but we haven't seen any application of that either. So we'll have to wait and see on that. I would not rely on that provision, especially if you're trying to beat the date for a date of entry for certain tariff programs. Because it is this beat the clock. If you look at the China duties, there was an exception there for exported before April 4th. And on the vessel prior to April 4th, and in its final mode of transportation, or another one says or on its final mode of transportation. And if you met that deadline, you were only subject to the regular duties and existing 301 duties at that time. If you were exported between the 5th and the 8th, you had the fentanyl duties, the IEPA fentanyl duties of 20%. And then not after April 9th or later, when the China duties went up to 125, the IEPA reciprocal tariff duties came into effect, a total of 145. You're going to be subject to those depending upon our export date. But again, we talked about certain exclusions for those reciprocal tariffs that also apply to China, 232 for metals, autos, auto parts, and those would still apply on those as well. And again, for our tech goods, that we talked about earlier, then those reciprocal tariffs are removed as well. Okay. De minimis. Now, like I mentioned earlier, this is the duty-free treatment of goods that are valued at less than $800. And we're seeing this from a number of countries, but China and Hong Kong being the primary one that it was targeted here, and that is eliminated as of May 2nd. There is also a restriction on postal shipments. These now are required to be subject to entry, or for our non-postal shipments, meaning through FedEx, DHL, UPS, those sort of things, those are now being subject to informal entry in most cases. That allows us to clear the goods a somewhat expedited basis, but with the payment of all duties applicable. Customs can always require a formal entry. With our postal shipments, which I hadn't realized was a very large portion of this, because of the capabilities of the systems and the like, they've pushed it on to the carriers of these postal shipments to collect either 120% of the value or $100 per item as of May 2nd, and $200 as of June 1. And what I'm hearing anecdotally is that a lot of carriers are electing to do the flat fee rather than trying to do the percentage fee. There's a lot of issues with this as well, because the carriers have to report total number of items, all the values, etc., which that a lot of this information has been added to the manifests over time to allow for the claiming of de minimis, but now for the collection of duties, which becomes a major issue. And the carrier bonds have to increase to cover these additional duties. So, those are generally 10% of the total duties fees over an annual period, so that number can be extremely significant. As I mentioned, customs can always elect to require a formal entry. Again, certain informational materials, personal communications, donations, personal baggage, things like that, there are some very limited exceptions to this amount. But keep in mind that the de minimis shipments from other countries other than China remain unchanged. And careful there. There's been some talk about re-exporting goods via Canada and Mexico that are of Chinese origin. It's based upon the origin of the goods, not the country of export of the goods. So they will be subject to these restrictions if it's still a Chinese origin good re-exported from a third country.
Okay. All right. So now we'll talk about, so by the way, we're slated from, for us, I guess 12 to 1, but we can stay on if you have questions for afterwards. You can email them to Cory's team. They'll send them on. We're happy to field some questions if you like. Okay, so I mean, some of these tariffs are based on a tariff classification. We have this tariff classification system, which is international, but it's set up, each country has their own variations. So here's an example where customs classified gaiters as hats. Anybody who's been a skier or been outdoors with one of these gaiters know it's not a hat, but we got it classified more as scarves, shawls, muffler type thing. So the benefit was hats were subject to this 25% duty, the old Section 301 duties, and gaiters were not. So now we see this lists of things. If you're on this list, you get hit with a certain 25% duty, right? Like auto parts or Section 232, aluminum or metal derivatives. If you're on a different tariff schedule, then you're not hit with those parts. So your clients may want to start looking at their products, see where they're classified, and see if they can get it classified under a more favorable duty provision. The next example, you can flip the page, David, was one, we did the same thing for air conditioning units. We found out that if you imported them separately, you were better off than you imported them just as a unit. Again, it's just a classification exercise. Okay, let's go to the next one. Okay, we're getting a lot of these country of origin situations. So people say to me, well, I have a product from China. What if I just send it through Canada? Does that eliminate the problem? The answer is no, because it's a product of China. There's duties on products that are made in China. Just sending it through another country or doing relabeling or repacking is not going to help you at all. What you need to do to change the country of origin, you need to create a new article of commerce with a new name, character, and identity. So here's an example. I do a lot of work for footwear clients. What they're going to do is, if possible, they're going to take components from China. Remember, they started off with a product in China. They're going to take components from China and then send them to Vietnam where they're going to make a shoe. So the question will always be, how much can I still keep in China as a process? Because they want to keep as much as possible. And we know that if they create the upper, they sew all the components for the upper together, and then they send the upper and the outsole and so on to Vietnam, and they do lasting there, which is a shaping, forming operation. That will create a substantial transformation, and therefore I have a change in process, change in country of origin. Sometimes we see, and now change in country of origin will happen where the second country is either manufacturing or has a complex assembly. But sometimes there's no complex assembly. It's just a simple assembly. And then what customs will do is, and this is an example here, motor controllers, they'll say, all right, what are the components that are going into this second country, and which components provide the essential character of the product? Those essential components, the country of origin of those essential components, will determine the country of origin of the product. So again, China's at, remember, 20 plus 125. Vietnam is just 10. That's the place you want to be if you can, right? So we're getting a lot of that kind of work. Let's move on to value, which is also pretty big. So all these duties, we say a percentage, but it's all a percentage of dutiable value. So if we can lower the value, then we lower the duty to be paid. So let's talk about the last one first. Buy on an LDP or DDP basis, right? So some clients were buying on, I would say most importers were buying on FOB foreign port basis, right? So then they would make the arrangements to put it on the vessel, pay for international freight charges, which, by the way, are not part of dutiable value, and they would be the importer record. What's happening a lot of times, these people say, well, things are crazy out there. It's very uncertain. I don't know that I want to be the importer record and have this risk. And vendors are stepping up to the plate saying, okay, we'll be the importer record. So we will sell to you, Mr. Previous Importer. We will land it. We'll be the importer record and we'll sell it to you. We'll bring it to your door, right? So the problem is, it sounds great, right? We're out of the problem of worrying about tariffs. You run into two problems. First, for a company to be an importer of record, they have to have a financial interest in the merchandise. If it's the factory or the seller, they have a financial interest. But what a lot of these people do is they'll just find some freight forwarder and they'll make that person the importer of record. That person is a stranger to the transaction. So we need to work it out so that the importer of record has a financial interest in the merchandise. They can be a buyer and reseller. They can be an agent of the seller. Those things work. If they do not have a financial interest, customs might reach out to them and say, who are you? And they'll say, well, I have nothing to do with this. I'm just the importer of record. Customs will not let that entry go. That means goods will not be released, and importers are very upset when their goods get held. The other problem is that some of these people are very cute, right? And filing improper entries, ridiculously low values. Customs grabs it. They won't let it go. They'll make them enter at the DDP price, and maybe they'll back out duties, but it'll be a higher value than it should have been if it was done right. There's also some concern for the ultimate consignee now about what is liability. So you want to put something in the purchase orders to protect the consignee that says, Mr. DDP vendor, you're going to file your entries correctly and you're going to hold me harmless in the event that people start bothering me because you're messing around, right? So those are the issues. So many people wanted to do DDP, and there's a lot of risk there. Okay, the next ones are also common. We've been doing them for a long time. Here's the first sale program. So here's how this works. Most of the goods that are imported are valued under a formula called transaction value. That's the price at which goods are sold for export to the US. So sometimes you have a multi-tiered sale, right? I have a sale from a factory to a trading company, and then from a trading company to the importer, right? In the past, quite often, all the customs would know about was the invoice from the trading company to the importer. I mean, here we have it $1,000. But you see that company's making a markup, 10, 20, sometimes 30%. So here we have a related or unrelated factory selling to the middleman at 700. So we want to work it out so we can prove that the sale from the factory to the middleman is a sale for export to the US. So dutiable value goes down to $700, right? And what's critical there are two things. One is the documentation between the middleman and the factories. They have to show that it's a sale for export to the US, right? I mean, that's a big deal. And second, the middleman can't just buy and sell at one point. He has to have a title and risk of loss ownership for some period of time. So we work with the people to make sure this happens. One of the big stumbling blocks is the middleman doesn't want to identify the factory to the importer or doesn't want to identify his markup. So there we have to explain to the middleman that we don't want your profit, we just want your markup. We know that you have expenses, so if you have a 30% markup, we know that your profit's much smaller, and we're going to work together, win-win, and we're not going to use this to beat you up on the prices, right? So there's those issues. The other issue we run into is if it's a related factory price. All accountants out there deal with related party pricing all the time. But here we have these customs tests that we use to determine whether the price between related parties is a fair market price. So we would have to make sure that the price intercompany, the $700, is a fair market price. And we look to unrelated factories. There's a whole host of things that we look at. The last thing that we talk about is sometimes these goods go to a warehouse before they come to the United States, and we have to show that the goods are destined for export to the US when they're sold from the factory to the middleman. It's very fact intensive. We try to set this up in advance. We recommend to our clients that we tell customs what's going on. It's just a filing. We're not asking for permission. We're telling customs, hey, company X is going in a first sale program. Here's what their documents look like. We almost never hear back from customs based on this letter. Somewhere down the road, customs may ask about it. We feel that having filed this letter, we protect the importer in terms of potential penalties, but customs can make value advancements, so duties would always be in play. Okay. The last program we're going to talk about is the buying agency situation. So a lot of times the middleman doesn't want to work with us, or it's creating a problem. So we do these buying agency situations. So let's go to the next slide, David. So these are the kinds of things a buying agent does. Basically, they find you factories, they do quality control, they help you in price negotiations. They're, and there, what we need to do is we set up a buying agency agreement between the importer and the agent. It's usually a percentage of the FOB price. Buying commissions run from, I don't know, 5 to 10%, like that. If you go higher, customs might knock it out. And the important elements of this is the buying agent works on behalf of the principal, who is the importer. The principal makes all the decisions, which factory we're going to use, what the price is, terms of sale. The buying agent gets a fee, doesn't share it with the factory, and the factory does not pay any of that money back, the price of the goods back to the buying agent. So we set those up. We don't do any filing with customs. And here it gives you an idea. You're basically buying from a factory and you're paying a separate commission to a buying agent. Sometimes people pay the buying agent who pays the factory. We just have to be able to have the right document flow um, to support this kind of effort. Okay, I think that's pretty much. Oh, we have a couple other slides about some more things coming, right?
Yeah, so there's a number of investigations that are ongoing now, some of which comment period has passed, some of which comment period is still open. Um, you know, affecting everything from timber to copper and derivatives, pharmaceuticals, semiconductors, critical materials, which can also include electronic products and those sort of things. They're derivative products. Um, they're ongoing investigations. We have to see what the agencies determine there, what products are going to be covered by the scope of them, what the proposed activity will be, probably 25% from what we're seeing. As we mentioned earlier, all of these under this statute, the agency has 270 days to do the investigation, but we can anticipate that these investigations will move much quicker than that, after which the president will take action. So, even if your products are not subject today to a lot of these issues, which they probably are to a certain extent, but they could be subject to additional duties down the road. So keep those in mind. Keep your eye on the trade press to see, where those are going, and what the outcome of those are.
Each one of these things, if they come to fruition, is going to create a major uproar. Pharmaceuticals are going to make people nuts, and timber and lumber and so on, going to really upset people in the building industry and so on. And everybody is pushing back and lobbying. And from what I can see, it makes a difference. I don't know. I mean, there was a meeting supposedly within the last week where the CEOs of the biggest retailers went to the president and said, "You need to do something here in 6 weeks. My shelves are going to be bare." And after that, he made an announcement that the duty rates on China are going to come down. We hear rumors that they're going to come down to half. Um, I'll mention one thing that some of our clients are doing. Merchandise arrives now. Let's just say it's from China, and it could be subject to this 145% extra duty. Some people are putting it in a bonded warehouse, hoping that there's going to be a break in the next month. They don't need their merchandise for a month. And then when they withdraw those goods from warehouse, the duty rate on the date of importation is what will be imposed on them. So some people are doing that. I think bonded warehouses are in great demand as a result of that kind of thinking. People can't absorb, better than we do. They can't absorb 145% tariffs. So what are we seeing? Pushback to the vendors. They're taking a bit of a hit. Our clients are going to take a bit of a hit, but a lot of this has to go on to the retail or the wholesale customer who's using it. There's a conclusion. I mean, it's nothing more than we've been saying. It's you folks are doing tax planning all the time, so this is the same kind of thing, but for customs. A lot of clients didn't care. Wooden furniture used to be duty free, and now if it's from China, the numbers are through the roof. Anyway, if people have questions to us, please send them on. We're happy to help. Yeah, we're going to share the slides. I guess Cory's going to have somebody make the slides available to anybody who attended. I don't know, Cory, if we're set up to take questions now. You're muted.
Hear me now?
I can't hear you.
Talking.
Yeah, your volume's very low.
How about now? Any better?
Perfect.
Oh, okay. There is a question. I don't know if you answered it already, but I'll read it. How would a product be subject to USMCA, but will be origin Canada or Mexico? If it's not made in Mexico, isn't the country of origin the country of manufacture and subject to 10% universal reciprocal tariff instead of the IEEPA 25%? But I think you did cover that.
Yeah, so in that situation, the issue will be whether or not you meet the country of origin rules under the USMCA agreement, these tariff shift analysis. Final production, of course, is the issue, is one part of that, but also, whether or not the overall production process results in our change in the tariff classification of the goods.
Okay. One question I have is the investigation. That's new for me. Can you kind of explain what that is about when you had that slide earlier?
So each of these provisions, 232, 301, provide that there must be an underlying investigation of the issue, whether it be unfair trade practices or national security. The agency, Commerce, USTR, whatever agency is charged under the statute, has to come back with a determination that there is either an unfair trade practice or there is a national emergency affecting the product, like they did in the original 301 or the original 232 on steel and aluminum. And therefore, based upon that it is necessary to take action. IEEPA doesn't have that. That the presidential action goes forward upon his determination and his alone that there is a national emergency.
Right. So basically what they'll do is look at import trends. They'll look at the practices of foreign governments. They'll look to see what the impact of these importations are on the U.S. Industries. And from that, they prepare a report, a 232 report.
Okay. Next question. We import. I don't know if you guys can see. Can you guys see the questions bottom right corner Q&A? It's got 3 there.
No, I don't see any.
Oh yeah, at the bottom of our slide. Here we go.
Yep. I understand goods subject to 232 are exempt from 125% reciprocal, but are they subject to 20% additional fentanyl tariff?
Yeah, if they're subject to 232, that's 25%. Yes, they would be exempt from the 125, but they're still going to get hit with the 20%. There's nothing exempt from the 20% except for, no, I don't think there's anything exempt from that. Nope, not even the electronics, right, Dave?
Right. Yes, informational materials and certain minor, but nothing commercial in that sense.
Right. Okay. We import, oh, that's pretty fancy stuff.
Acrylonite, yeah, okay.
Polyacrylate, which we use to manufacture carbon fiber. Would the definition of critical materials referenced in your slide include any of this? Carbon fiber is a pure carbon, a mineral.
I don't know. We'd have to look at the actual investigation to list what they were looking at there. It's a lot of the rare earth minerals. I don't know whether carbon, because that's something that, is probably more readily available, may or may not be covered by it at this point.
Okay, well, we are past our hour. Great subject. Both Robert and David, thank you for your time. Hopefully individuals got some information, golden nuggets, as I call it, from this. This is a hot subject. And again, if you do have specific questions regarding tariffs and how you can minimize the impact on your organization, I definitely would suggest that you reach out to Robert and David. We will be sending everyone that signed up to this webinar both the PowerPoint presentation as well as the recorded webinar and contact information for both Robert and David. Again, I want to thank you both for your time and appreciate your knowledge on this subject as we wade through it.
Thanks for the opportunity to address the group, Cory. It's a pleasure.